the 25th Amendment and impeachment. We've all been hearing a lot about these topics in the news lately, and it was suggested to me that it might be good to do a little seminar on these topics to educate the students at PNCA, faculty, staff, some of our board members might be here. And I think this is also open to the law students at Willamette. So when this was suggested, my very first thought was, I wonder if there is a professor at Willamette University's College of Law who might be interested in presenting the content for us. And so I emailed the dean down there, and both of the professors that we have here today volunteered almost immediately. So I want to thank you, gentlemen. We're going to start today with Professor Gil Carrasco. Gil and I go way back. I've known him probably since 2006 or 7. Seem right?
Even before.
Even before?
When I taught at Lewis and Clark, probably.
That's right. So Professor Carrasco is a tenured professor of law at Willamette University. He specializes in teaching constitutional law, the lawmaking process, civil rights litigation, and immigration law and policy. And all of the professors teach a variety of other courses from time to time too. Interestingly enough, in a previous assignment, Professor Carrasco taught constitutional law and public policy with the late Congressman Peter Rodino Jr., who happened to be the chair on the Judiciary Committee during the impeachment of President Nixon. Professor Carrasco is a prolific author. Most recently, he has written a text on or an article on Bivens in the End Zone. The court punts to Congress to make the right of action play. And this will be published soon in the University of Miami Race and Social Justice Law Review, probably the spring of 2021. Thank you very much for being here, Professor Carrasco. Professor Carrasco will be talking to us about impeachment, and he will go first, right after I introduce Professor Green. Professor Stephen Green is the Fred H. Paulus Professor of Law and affiliated Professor of History and Religious Studies at Willamette University. He teaches courses in constitutional law, First Amendment, legal history, education law, and jurisprudence in the law school, and religious history in the undergraduate college. Also a prolific author, Professor Green has most recently written a book entitled Separating Church and State, A History, published through Cornell University Press. Professor Green will be talking to us about the 25th Amendment, and the two professors will probably have a question or two for each other. Once we are done with their presentations, I will throw this open to questions from our attendees, which you can enter through chat, and I will read to Professor Carrasco and Professor Green. So thank you all for being here, and Gil, it's all yours.
Thank you, David. It's great to be with you again, even if only virtually. And hello to my colleague, Professor Green, and welcome to all of you from the Pacific Northwest College of Art and the Willamette Law folks who are with us as well. I want to begin just by pointing out a couple of relevant passages from the Constitution. And I think that most of you are probably familiar with the main provisions. But of course, in Article 1, Section 3, Clause 6, the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. And then Clause 7 of that same section provides judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So, of course, we are in the throes of the impeachment and trial of President Trump for incitement to insurrection. The most relevant provision of his speech or his remarks on January 6th was, quote, "If you don't fight like hell, you're not going to have a country anymore." And of course, that resulted in his impeachment on the article of incitement to insurrection by a vote of 232 to 197, 10 Republicans joining the Democrats for that result. I want to highlight just a few high points because we're given limited time and we really can't cover all the bases. But one of the things that I think is important to note is that once the articles of impeachment, or the article in this case, is transmitted to the Senate has 1 day to act. And so it must begin the trial on the impeachment as soon as Nancy Pelosi transmits that. Actually, this morning, she communicated to the Senate that an impeachment vote had taken place, but she did not formally transmit the article of impeachment. Now, the question that many of you probably have is, can a person be tried for an impeachment after he leaves office? And there is some precedent for this. In 1876, for the impeachable offense of bribery, Secretary of War William Belknap was impeached after leaving office. There's another precedent regarding Senator William Blount in 1797, although it's fairly universally held now that members of Congress cannot be impeached. They can be removed from office through other means, and we'll talk about that. There is historical precedent as well, going back to England. And of course, we take our common law and our traditions from the British system. And there was an impeachment in the UK after leaving office of one Hastings, the former governor of India. So we do have a long tradition of this phenomenon. Another question that has been raised recently is, what is going to be the representation of Donald Trump in the trial in the Senate? Rudy Giuliani has been dismissed, or he's not going to be undertaking the trial, and there are many others who were thought to be candidates for representation, but they're not going to do it. The defense attorney in an impeachment trial can be a member of the House or the Senate. And my speculation is that that's probably what will happen in this case. Another notable point, a pardon cannot undo an impeachment. And so if the president is tried and convicted in the Senate, that's not something that anyone can pardon him for. Also, a person cannot self-pardon. This is the subject of a lot of discussion recently. The reference to the term grant in the pardon clause indicates that someone can only extend a pardon to someone other than oneself. The other question is, well, what is the significance of a conviction in this setting? And I think the primary importance is disqualification from future office. Judge Alcee Hastings was impeached and convicted, and then later, after being disqualified from his judgeship, ran for Congress and continues to serve in that body. So there is also precedent for that. So that's the reason why there will be a trial in the Senate. Just a couple of historical notes. James Madison was of the view that a limited tenure in office for the president was not a sufficient security, and the phenomenon of impeachment was thereby included in the Constitution. Alexander Hamilton, another of the framers, said that an impeachable offense is one that inflicts, quote, political injury, end quote, on a democratic society. That was in Federalist number 65. And then George Mason said that treason, which is one of the offenses that is impeachable, fails to capture all attempts to subvert the Constitution, and therefore other high crimes and misdemeanors was included in addition to treason and bribery as the potential grounds for impeachment. Edmund Burke, another of the framers, said that, quote, statesmen who abuse their power are tried not upon the niceties of a narrow criminal jurisprudence, but upon the enlarged and solid principles of morality, end quote. And so criminality is neither a necessary nor sufficient ground of impeachment. There are other particulars with regard to the pedigree of impeachment. As early as 1386, the Earl of Suffolk in England was impeached for a misdemeanor. And the term misdemeanor didn't take on a criminal connotation until the 16th century. Actually, at the time it was used in the Suffolk case, misdemeanor was defined as a tort or civil wrong. And so to this day, high crimes and misdemeanors is not intended or construed to connote criminality necessarily, although it may. Also, Max Farrand, who is widely viewed as the primary interpreter of the proceedings of the Constitutional Convention, said that high crimes and misdemeanors include only offenses that either entail subversion of the constitutional order or involve serious abuses of official power. And then finally, Larry Tribe, I think, puts it well in defining impeachable offenses and says that a president who intentionally lies, whether or not under oath, in order to interfere with the proper functioning of a coordinate branch in furtherance of a scheme to achieve some policy goal of that president's administration, or in order improperly to seize or maintain executive power, has probably committed an impeachable offense because such a corrupt aggrandizement of power is precisely the kind of conduct that the structural check of impeachment was designed to prevent. And so I think that that really describes Trump's actions. He was actually imploring the crowd to go to the Capitol and to prevent or impede the counting of the electoral votes. And so that is very much within the realm of an impeachable offense. I'll just conclude by mentioning a couple of things with relevance to the process. Interestingly, House Manager Lindsey Graham, who oversaw the impeachment of President Clinton, said, quote, "The White House is the bully pulpit, but it should never be occupied by a bully," end quote. Lindsey Graham said that. Well, there are a lot of people who are singing a different tune these days, and that kind of underscores the partisan nature of the Congress in recent times and of the White House as well. The standard of proof is probably somewhere between the civil and criminal poles of proof. I think that the primary evidence of the relevant standard of proof was in the Nixon impeachment proceedings before Chairman Rodino and the House Judiciary Committee. Clear and convincing evidence was the standard they adopted. Charles Black, a prominent commentator on the Constitution, said an overwhelming preponderance of the evidence would be the appropriate standard. So it's not proof beyond a reasonable doubt, as would be the case in a criminal setting, or it would not be a mere preponderance of the evidence that would be applicable to a civil case. So I think I'll leave it there. There's a lot more to say, but I think that we're limited in time, so I'll turn it over to my colleague, Professor Green.
Thanks, Gil, and thanks for the invitation to talk about this issue. I'm actually teaching my course in the Presidency and the Constitution, so it was good timing to plan this out back last fall when we were doing the schedule. I had no idea exactly what would be happening, but with the current occupant, at least for the next 22 hours of the White House, we knew that with potential for there to be something come up. So let me pick up on a couple of points that Gil said, because I think it's just important to reemphasize this. Impeachment is a political act, right? And so let's not get confused, because you're going to hear a lot of misinformation, right? That what Trump did not rise to the level of criminality. Okay, these are quite distinct things. An impeachable offense can be criminal, but it doesn't have to be criminal, right? And this is what we see that the drafters of the Constitution are concerned about. And so I'm actually having my students read excerpts from some of the arguments. And it's actually very enlightening to see how much foresight many of the drafters had. And actually, I always start off with one of my favorite quotes, and this is from Benjamin Franklin. And he's near the end of the convention, and he's looking up at the dais, and there's George Washington, who was the president of the Constitutional Convention. And everybody knew he would be president. There was no doubt. He was the only one who could do it, right? And so Franklin gives a speech, and he says, the first man to be put at the helm of the presidency will be a good one, but nobody knows what sort may come afterwards. And so there's already this anticipation. I don't think anticipation is something like Trump, but anticipation that we might have people less qualified to be president who might actually get the realms. And you do see from some of the comments, as Gil was mentioning, what were they most concerned about? And they were most concerned about abuse of power. That in essence, someone who would take the reins of all the power that the presidency had would therefore use it for his own purposes. And so we see that William Davey, who ended up being a Supreme Court justice, he said, if he's not impeachable while in office, he will spare no efforts or means whatever to get himself reelected. And so he considered the impeachment to be an essential security for the good behavior of the executive. And then George Mason basically said, once again, emphasized that no man should be above the law. No one should be above justice, he said. He says, shall a man who has practiced corruption, and by that means procured his appointments in the first instance, be suffered to escape punishment by repeating his guilt? It's almost like they were somehow, had a time machine, and they saw what had been going on for the last 4 years, but they anticipated this, right? Okay. So again, and one of the other concerns, we saw already kind of mentioned this, but one of the main concerns was that the president would engage in election fraud and try to perpetuate himself in office. And so we can look at the various impeachments that have taken place. Andrew Johnson, back in whatever it was, 1867, 1868. We can see Nixon potentially should have been, Clinton. By far, what Trump has done meets the qualifications, if anything does, for impeachment. This was the primary concern that the drafters had for this. Okay. So I guess the question is, why do it? Right. And Gil is correct. I think there is precedent, even though precedent can be broken, that you can actually try someone or even impeach somebody who's already been removed from office. And the practical consideration is to disqualify them for being able to hold any federal office in the future. Okay. But I think there are other reasons to do this, right? One is just the sense of accountability that people should be accountable for their actions. There's a need for deterrence to deter other people from potentially doing the same thing. I mean, if we had had this discussion many years ago before Trump, who broke all these norms, I think we would say possibly deterrence is not anything we need to worry about. But things have changed. And so consequently, we do know that deterrence is an important factor. Reaffirming the rule of law. And then I think a very important thing that we need to have and to move forward, and I've been emailing back and forth with some colleagues who teach overseas, is this reaffirmation of the kind of American democratic process, the peaceful transfer of power to our allies. This is essential for American credibility. And so consequently, some people obviously will be arguing this is a waste of time, it's pouring salt on the wounds, whatever metaphor you want to use. But I think it's a very important process that we go forward with this. Okay. One last point. There actually is a potential alternative that is out there, because I really do not see the supermajority necessary in the Senate probably to convict Trump, even though they should. There actually is a section in the 14th Amendment, the Civil War Amendment, Section 3, that actually provides that if you have engaged in insurrection against the United States, that you can therefore be disqualified from holding any public office under the federal government. Okay. This was for the purpose, of course, of trying to prevent the former civil Confederate generals from being elected to office after the Civil War. What that would take is it would take actually a bill. It would take a piece of legislation from Congress that would say, if you've engaged in insurrection to try to prevent the peaceful transfer of power, you shall therefore be disqualified for federal office in the future. And so if impeachment fails, there is a possibility that Congress could go forward. It would have to be signed by President Biden, but to prevent ex-President Trump from ever assuming office again, which I think would be a very important thing to cover. Okay. So those are my more or less comments. Should I segue to the 25th Amendment, David?
You're on.
You're on mute.
I think that's, let's do that. And then Gil, you'll have a chance to ask any questions or clarify anything after Professor Green, and then we'll throw it open to questions.
Okay. Well, let's talk about the 25th Amendment. And here we're talking about a particular section of the 25th Amendment. This is called Section 4 of the 25th Amendment. You've been hearing this being thrown around. And this is the process where, short of an impeachment or resignation, that the president could be removed from office through the vice president and the cabinet. Okay. And so there was some encouragement last week, if I remember, where Speaker Pelosi was urging Vice President Pence to use the 25th Amendment to try to remove Trump from office in the last week or so. Pence, notwithstanding the personal threat on his life as a result of the insurgency, and apparently the break that has taken place between Trump and Pence, he still declined to go forward with the 25th Amendment. Okay, so what's the 25th Amendment do? Okay, well, in a nutshell, at least in my interpretation, it probably is the most ineffective provision in the Constitution that exists. It was put into place as a result of ongoing concerns that you might have a president who is disabled. And disabled is actually not the actual word. It is his inability to discharge his powers and duties. And that actually goes back to Article 2 of the Constitution proper. Right? But there was some history. And the history was, as you had James Garfield, who was elected in 1881. Within 3 months of him assuming office, he was shot when he was in a train station. And that's back before you had really any Secret Service protection, right? So shot in the back. It was actually not a lethal shot, but through the malfeasance, if you want to call it that, or mispractice of doctors at the time, who were sticking their fingers and probes into his back, trying to find where the bullet was, he suffered severe infection. And so he languished for about 3 months before he finally died. Okay. Now, he until the end, he was pretty much in command of his faculties. Once again, like I said, it was not a life-threatening shot as it was. But then again, the question became, I mean, who was going to be conducting the affairs of office? James G. Blaine, his Secretary of State, who was with him at the time he was assassinated, he kind of took over some of these powers, right? Because Garfield had a falling out, or he never actually had a falling in with his vice president, who ended up assuming the office. Okay, so you had that instance. Woodrow Wilson, back at the end of World War I, in the process of trying to get the United States to support the League of Nations, which is a precursor to the United Nations, you want to think about that. He suffers a stroke in October of 1919. And the stroke is quite disabling. It's so disabling, in fact, that he's paralyzed half of his body. He kind of goes in and out of his mental capacities. And that is hidden from the American public by his wife and his chief of staff, right? And so he basically lives out the final year and a half of his presidency in a state of disability. Then you had, of course, FDR, who more or less at the end of his life, he had also his medical disabilities from everybody, and he also apparently, because of his heart disease, was beginning to have some mental questions about his decisions. Right at the time we're into World War II, and he's trying to decide whether we're going to go forward with an atomic bomb. Important to have a president who knows what's going on. Okay. So after the assassination of John F. Kennedy, finally, Congress said, I think we need to do something about this, right? Because even though it's quite clear John F. Kennedy died immediately when he was shot in the head, everybody realized there could be other situations where you might actually have a disabled president. So what do you do? Okay. So the purposes behind the 25th Amendment are all good. To allow for there to be a transfer of power to the vice president, even if the president is unable to resign and do it himself. There is one clause in the 25th Amendment which has been activated, Clause 3, which actually allows the president on their own to say, send a letter to Congress to say, I feel I am not going to be able to carry out the duties of my office. So consequently, I am temporarily giving the power to the vice president. That has actually been activated in a very minor sense when you had President Reagan, after he was attempted assassination, when he had to go undergo surgery. He more or less communicated this letter that said, I will possibly not be able to do this. We need to allow the Vice President Bush to potentially take over. Okay, but that's when the president does it voluntarily. The clause we're talking about is when the president does not want to be removed from office. And the reason this is the most ineffective part of the Constitution is the way it was written. It requires the vice president and a majority of the cabinet. It's actually not clear whether it's the full cabinet or whether it's also any Senate confirmed heads of departments, which would actually expand it even beyond what we consider to be the traditional cabinet. But you have to have a majority of the people that the president has actually appointed to their offices, right? To say the president should be removed because he is unable to go forward and discharge his duties. But the kicker is it requires the vice president. So even if you have a majority of the members of the cabinet who think the president should be removed, the vice president can trump that, pardon the pun. So the vice president can basically make that determination almost on his own of whether to remove the president. Even if you get the vice president and a majority of the cabinet to go forward with this, the president, what happens is once they send that letter to the Speaker of the House, President Pro Tem of the Senate, that effectively then the vice president becomes acting president. The president can send his own letter back to the same individuals, President Pro Tem and the Speaker of the House, and say, wait, no, I am able to discharge the duties of my office. Then it becomes a battle about who should potentially prevail. The vice president still is effectively the acting president, but then it has to go within 21 days to a vote in the House and the Senate, once again, a supermajority, 2/3. And so you can see the hurdles to remove a president who is disabled. Okay. Now, the 25th Amendment is not necessarily limited to like a disability, like having a stroke like Wilson did. I mean, the terms they use are broader than this, unable to discharge the powers and duties of the office, right? So inability, is the term used, not disability. So it can be broader than a disability, right? And so technically, yes, if you could say that the person who's in power in the presidency is a megalomaniac, he's not discharging the duties of his office, he's uncontrollable, that would suffice. But again, what you have to do is you have to get a majority of the cabinet plus the vice president. Then you would have to, if the president objects, have supermajority of both houses. Right? So I don't think we're going to see this happen anytime in our lifetimes or in future lifetimes, unless it is just so clear that the president, once again, has a stroke, completely unable to fulfill the duties of his office and goes forward. And therefore, you would have this kind of unanimity of thought that we need to have the vice president become the acting president. So it was a stretch. It was a kind of a dare, and I think it was more of a procedural move by Speaker Pelosi, more or less saying, we're going to show restraint. We're going to put it in your court, Vice President, you and the cabinet do the right thing. And once they decline to do that, then to go forward with the impeachment process and trying to give the impeachment process a little bit more legitimacy. Right? But consequently, it's a relatively ineffective, if not completely ineffective, provision in the Constitution. And so it really kind of relies, the Constitution, I think, kind of relies on presidents doing the right thing, like Richard Nixon finally did. He resigned from office. Or impeachment, which I actually think, as a legal historian, that the framers thought would actually be used more frequently, would actually be a greater threat to managing presidential abuse, to manage tyranny. It's become almost this third rail, which makes it very difficult for anybody to be impeached, because once again, you need 2/3 of the Senate, even though it's only a majority of the House, to actually impeach. Quite clearly, the framers did not want impeachment to be used for policy disagreements. And I believe they actually thought it would almost be clear in everybody's mind when someone had crossed this threshold into an impeachable offense. Well, abuse of power, attempt to overthrow or at least undermine the constitutionally ordained transfer of power, to interfere with the operations of another branch of government, let alone actually the violence associated in that process, should qualify for impeachment if anything has ever qualified for impeachment.
Thank you, Professor Green. Gil, it's your turn if you have questions or comments about the 25th.
I'll be brief. There was one other instance, actually, where the 25th Amendment was invoked. That was with George W. Bush having a colonoscopy and Vice President Cheney taking over for him. The question of the 25th Amendment is not new with regard to Trump. As long ago as August of 2017, Republican Senator Bob Corker from Pennsylvania said this, quote, "The president has not yet been able to demonstrate the stability nor some of the competence that he needs to demonstrate in order to be successful," end quote. In fact, he was said by Senator Corker to pose such an acute risk that a coterie of senior administration officials must protect him from his own instincts. Of course, it's irrelevant probably that Rex Tillerson called him a moron, but more importantly, there were other critics who were screaming mental stability and intelligence as compensation for the Russia investigation. And Trump responded that there was no evidence of collusion. And also in that context said, "I'm a very stable genius." So that led Jamie Raskin of Maryland to introduce HR 1987, the Oversight Commission on Presidential Capacity Act, because he said Trump's behavior is, quote, "increasingly delusional," end quote. Also, member of Congress Zoe Lofgren from California introduced a resolution urging Trump to consult a medical professional. So we have a long history now at this point, 4 years later, of Trump having his stability and mental competence or psychological wherewithal questioned. But I want to go to the 14th Amendment that Professor Green wrote, and I agree that this is relevant, but I don't think, and this is something with which I disagree that he said, I don't think that it's applicable to the President of the United States, nor the Vice President. The impeachment clauses were specifically included for the purpose of removing the President and disqualifying from office. The 14th Amendment, Section 3, refers to electors of President and Vice President. Those are people like those who voted to reflect the slate of Vice President Harris and President-elect Biden, whose votes were being counted at the time of the insurrection. Also, members of Congress can be subjected to this disqualification. And I think that there is some effort afoot to disqualify, for example, Senators Hawley and Cruz for their participation in the big lie, as it's being called, the proposition that the election was stolen, there was fraud in the election, and 60 cases later, there was no demonstrable fraud in the election. And in fact, Trump's own national security advisor represented the fact that this is the most secure election in the history of the United States. The disqualification to hold office provision could be useful, and it could be invoked against members of Congress who, for example, are members of QAnon and who aided and abetted the insurrectionists who were in communication with others before the attack on the Capitol and so forth. David, you asked me to ask Professor Green a question, and I have a question that I don't know the answer to, and that is the requirement is that the Senate act on the transmittal of the articles of impeachment to the Senate within 1 day. And I wonder if you know whether that refers to a legislative day or a calendar day.
Yeah, well, my sense is probably a legislative day. And of course, the Senate has its own rules about how it goes forward with these procedures. And generally it is, my assumption is it's just that the articles of impeachment must be formally filed with the Senate, and then the Senate makes a determination that they are going to go forward with it. They don't have to start the trial on that particular day. And so consequently, they just go ahead with what the Senate rules are. But I assume it's a legislative day. It's not a calendar day. That just be my guess.
Sounds reasonable.
For the audience, could you tell us what a legislative day is and distinguish it from just a calendar day?
Well, it's when Congress is in session, right? So in essence, it has to be a day that they have the ability to take some type of action, right? And so not only does the Constitution more or less provide in various places about Sunday sometimes being a day where there would not be any kind of activities taking place, right? For the counting of days when it comes to pocket vetoes or vetoes, right? But in addition to that, it is if the Senate is not in fact in session or the House is not in session, then to say you have to have immediacy, that just doesn't fit within the way that the Constitution and the rules have worked.
Thank you very much. So I have a quick question that occurred to me when Speaker Pelosi made the request in writing of Vice President Pence to use the 25th Amendment to remove President Trump from office. My question was she offering a deal, or was she suggesting a course of action that then would have been followed by impeachment?
My guess is if Pence had gone forward with this, well, one, we know that Trump would have objected. And so it would have gone most likely to both houses of Congress. That would have been riskier to a certain extent for Pelosi, because then it would have required 2/3 of the House. And the likelihood of getting 2/3 of the House to remove him from under the 25th Amendment, what we've already seen, they only picked up 10 additional votes from Republicans. So I think it was more of just she wanted to, check the boxes. She wanted to show that she was exercising some restraint, that she wasn't rushing to do the impeachment without giving Pence the opportunity to go forward. So I don't really see there's any kind of quid pro quo going on here, or some type of bargain. Now, if this had happened and gone through the entire process of the 25th Amendment, and like I'm anticipating that you wouldn't have gotten 2/3 of the House to do this, if she would have then turned around and filed the articles of impeachment with the knowledge that you only need a majority of that, I actually think that would have made it look more of a partisan thing. Right? You lose in one, you try a different mechanism for doing this. So I think she's been around the block many times, and so I think she knows very well how things would turn out. And so I don't think she thought that there'd be a majority of this cabinet plus Pence would take this.
Yeah, I think that it was a way to let the Congress off the hook, so to speak, for an impeachment proceeding. I agree with what Professor Green said. I think the other interesting question that's posed today is how else can the Senate get off the hook? And I read at the very beginning the provision of the Constitution that it says, with the concurrence of 2/3 of the members present of the Senate with regard to a Senate trial. And I think that that's really important, because for those cowards who don't want to go on record in opposing Trump, and that's been the problem with the Senate for the last 4 years, they have a way to, duck the issue and get off the hook. They can have it both ways. They can minimize the number required for conviction, and yet they don't have to put themselves on a record against Trump. And I think that for that reason, we might very well have a conviction.
Okay, I have a question from Linda Hutchins. Does the concept of restorative justice have any applicability in the case of impeachment? Or is it only relevant for criminal offenses? What might it mean for Trump in relation either to his impeachment or possible criminal suits against him?
I have a response to that, and I think that Professor Tribe really stated it well. The impeachment process may also serve, for some, as a means of renewal and cleansing by restoring public faith in our polity's integrity and legitimacy. Also, to the extent that there is a trial in the Senate and there is a conviction, that does not mean by any means that there won't be criminal prosecutions of Trump and his family and his colleagues in the future. Now, I mentioned that Trump can't pardon himself. He can pardon those others, but only against federal prosecutions. The states can still prosecute all of these people, including Trump, for criminal violations of the law, including tax evasion and other similar violations. So I think that we have not seen the end of this, and Trump is going to be very busy defending himself against many criminal prosecutions, is my prediction, once he leaves office.
Steve, any thoughts?
Yeah, I'm not an expert on restorative justice. I've done a little study on it a long time ago. I mean, my understanding of restorative justice is it requires or necessitates the perpetrator to acknowledge their guilt and to try to work with the people who they have harmed to try to create some type of reconciliation. That's not Trump's character. He's just not going to do it. And so consequently, it would be nice. And I can see, I guess, the larger point. And we're going to hear this a lot from Trump supporters, right? Why are you doing this? Why are you going forward with the impeachment, the trial? Because it's just going to create more division in society. We need to come together. We need to have our kumbaya moment or something like that, right? Okay. Trump has bypassed the opportunity to have these kumbaya moments so many times throughout this presidency. And to say that we would not acknowledge the most serious threat to American constitutional democracy since the Civil War by virtue of what happened on January 6th. And to say, we're just going to take a walk on that just because we want to heal the nation. It's going to take a whole lot more than this to heal the nation.
So let's see, nothing else from the crowd. Here's a question for you. We hear in criminal cases or civil cases under the law about the right to appeal. Is there any appeal of a conviction of impeachment?
No, not at all. And that's very clear from the intent of the framers and the way also that the court has subsequently interpreted the impeachment clause when it comes to other officers. There have been over a dozen impeachments and removal. Almost all of them have been federal judges. And yes, exactly. There is no appeal from an impeachment. It's a political act. And one of the main reasons the court has said that, affirmed that, is because it really is the only way to remove federal judges. Federal judges have life tenure. And so if there were a way to appeal an impeachment for a federal judge, to where? To the federal courts, to their friends on the federal bench, that would just be completely inconsistent with the process.
And I think that somewhat relates to the pardon power as well. If you were able to pardon yourself as president of the United States, you could commit a murder in office the day before you leave office and then pardon yourself, and you would be above the law, essentially. And I think that it's very clear in terms of the pedigree of the pardon power going back to the king and British law and our system that we've adopted with the framers. It's impossible to pardon yourself. But that being said, it's at least arguable that abuse of the pardon power is a violation of the take care clause. The president shall take care that the laws be faithfully executed. So you could argue that Joseph Arpaio's pardon would be inconsistent with the pardon power. You could certainly suggest that pardoning members of his family for a conspiracy or common enterprise would be an abuse of the pardon power. It's probably not justiciable. I think the pardon power is plenary, but that being said, there are substantial questions about the legitimacy of the use of the pardon power by this president. And it's been disturbing, to say the least. One of the things that's also sort of percolating is the possibility of pardons for the insurrectionists. I, for one, think that the charges that were levied by the prosecutors in those 100 cases or so that have been filed thus far should have been much more substantial than trespassing on federal property and the like. I think that there's probably sufficient evidence in many cases for a conspiracy to commit insurrection, rioting, some really substantial sedition, substantial charges that would include some major time. But these minor trespassing and other relatively lenient charges are not going to result in even continued detention in most cases.
Yeah. So I have another question here. This is from David Ritchie. what happens when Trump leaves US territory? Would it be possible that he could be, under some circumstances, that he could be barred from re-entry?
No, not as a US citizen. I think the more interesting question in that vein is whether he could be extradited to the United States for trial. I can foresee Trump and his family packing up and getting out of town, because the writing's on the wall. They're going to face some substantial charges. The district attorney in New York and the attorney general in New York are already well on their way. I think it's just a matter of time before they face the music.
Yeah, he should have gotten that Trump Tower in Moscow built before he was elected president, so he had a place to land afterwards.
I'm sure Putin will accommodate him. He can reside next door to Edward Snowden.
I think, Gil, it was you that mentioned the removal of members of Congress from office. Could either of you speak to what the process is for that?
It's basically a majority vote. And then to remove that disability from holding future office or from holding office, the Congress has to vote by a 2/3 majority to reinstate the ability to hold office. That's the basic parameter. Steve, you might have something to add to that.
Yeah, well, Congress has power to remove sitting members for numerous grounds, for malfeasance, etc. Right? I mean, that exists in the Article 1 of the Constitution. So Article 3 of the 14th Amendment was an additional provision for stating instances of insurrection once again, right? Yeah, Congress already has power to censure, has power to take away certainly privileges so far as their committee assignments, etc. That's easy to do. They also then could actually remove someone from office. If I remember correctly, Gil, you can correct me if I'm wrong, that's what happened to Adam Clayton Powell, who was a Black minister, one of the first Blacks elected in the modern era to Congress. He was from Harlem, and he was accused of, I don't know what it was, bribery or some kind of economic crime. And he actually was removed from office. He ran again and got reelected, or got elected, right? He went back to Congress, and Congress tried to keep from actually sitting him. And the Supreme Court said, that's not within your power. You can't prevent him from actually being seated, but you can remove him. And so there are other grounds that Congress could use for removal of their co-members.
Yeah, Adam Clayton Powell met the requirements for membership in the House of Representatives. He was 25 years old, a US citizen, and so forth. So that was really the question before the Supreme Court in the Powell v. McCormick case.
Great, thank you. So it makes me think about something that a tactic that has been used on both sides of the aisle in Oregon, in our legislature, and that is a concerted effort to thwart votes by not showing up. The Democrats have done it, the Republicans have done it, and it appalls me. Would that be grounds for removal from office?
You mean if members continue to refuse to show up for a call for quorum? And I think that would be really hard unless you could show a consistent pattern of trying to somehow disrupt the operations of Congress and conspiring with others to possibly prevent a quorum from occurring. My guess would be that the leader of the Senate or the Speaker of the House, if there's just a member who's constantly absent and refuses to show up, that they would just see the recourse is that person go back to their electorate and not get reelected.
Yep.
And the question you asked about Oregon law is a question of state law, and I don't know the answer to that question. It's probably in the Oregon Constitution somewhere.
Yeah, nor do I. I just thought I'd throw it out there and see if you had any ideas. Okay, so we've got just a few minutes left. I see no further questions from our attendees. And I am out of questions. So I think unless you have any closing remarks, I just want to thank you very much for taking the time to prepare for this and for being here with us. I think this is certainly going to be one of the first of many, many, many collaborations between PNCA and Willamette and the College of Law at Willamette that we all very much look forward to. We've got some thank yous coming in from Anna Miltenberger and Jesse Spees Warner. We had a combination of faculty, staff, and students here in the watching today. Again, I want to thank you very much for being here with us.
I just want to express my delight at the Pacific Northwest College of Art merging with Willamette University. And we welcome you with open arms, and I look forward to future collaborations with you as well. Thanks for your attention.
Yeah, I concur completely. I think it's great. My wife is a fiber artist, and she just thought it was the greatest thing to see that there'd be some kind of collaboration, long-term relationship between the two institutions. So we really look forward to being friends and collaborators.
Well, thank you very much. Have a great rest of your week. Wish our country good luck and peace tomorrow. And we'll be watching, I know, all of us with interest. More thank yous coming in. Thanks so much.
Okay. My pleasure.
All right. Bye-bye.
Bye-bye.